Hello, and welcome to Do-It-Yourself Limited Conservatorship of the Person. My name is Mark Sullivan. I am not a lawyer. I am a parent of an autistic 21-year-old. This slideshow is being recorded after the Autism Conference presentation. All notes presented today on filling and filing the forms to petition California's probate court on limited conservatorship of the person can be found on the website raisingautism.net. Petitioning for conservatorship is complicated by the knowledge of how to fill in the forms and when to file them. But if you have the time, anyone can successfully go through the court process for the typical limited conservatorship of the person who has intellectual and developmental disabilities. While there are legitimate reasons to safeguard the rights of an individual becoming an adult, I believe parents of children with intellectual and developmental disabilities should not have to pay to continue to be the guardians of their child. This is why I created the step-by-step do-it-yourself. A good portion of the time is just gathering the information needed to petition the court. You have to do this whether you do it yourself or have someone else do it for you, in which case you also have to answer questions so they can fill out the forms correctly. In this session, we will go over the types of probate conservatorship, other options for hiring someone to help you, and how to use the website to file and fill the forms. The court and regional centers really want someone, and preferably the parents, to be the conservators of their intellectually and developmentally disabled children. Because if not, and the court finds a person in need of conservatorship during the process, the court has to pay for a professional conservator if the person is not a client of the regional center. And if they are a client of the regional center becomes the conservator. Probate court has a system of professional conservators, investigators, and lawyers. In the San Francisco probate court, lawyers who bring cases before the probate court also have to work for the court at reduced payment. This may not be the case in all probate courts. These are the conservatorships based on California probate code. The main one we're going to be focusing on is limited conservatorship. But this gives you an overview of what's out there. General conservatorship is conservatorship of adults who cannot take care of themselves or their finances. These conservatees are often elderly people, but they can be younger people who have been seriously impaired, like a car accident, for example. Limited conservatorships is conservatorships of adults with developmental disabilities who cannot fully care for themselves or their finances. Conservatees in limited conservatorship do not need the higher level of care or help that conservatees in general conservatorship need. You can think of general conservatorship as individuals who are on the decline with no hope of regaining their rights. Limited conservatorship are for individuals born with a disability but who are still learning and growing from their disabilities. There is hope by the court that some rights may be granted back to the disabled individual, which is where the word limited conservatorship comes from, in that rights, powers, and time are limited. You can also, the court may appoint a temporary conservatorship until a general conservator can be appointed. Request must be filed as part of the general conservatorship case. So this is if you run over past his age of 18 or her age of 18 and they still are not conserved. You can be appointed temporary conservator, or someone else can be until the full conservatorship goes through. The Latterman portray as short conservatorships are used to care for adults with serious mental illness who need special care. These conservatorships are used for people who usually need very restrictive living arrangements, like living in a locked facility, and require extensive mental health treatment. So this gives you a general overview. Most children with autism or developmental disabilities are going to go under a limited conservatorship. The probate court can appoint a conservator of the person or a conservator of the estate, or both, depending on the needs of the conservatee. Most autism or children with developmental disabilities don't have an estate, so there's no requirement. There's no need for a conservator of the estate. So a conservator of the person is for protection, cares for and protects a person when the judge decides that the person cannot do it. The conservator is responsible for making sure that the conservatee has proper food, clothing, shelter, and health care. Depending on the conservatee's ability to understand and make decisions, the conservator may need to make important medical choices for him or her. The conservatee of the estate handles the conservatee's financial matters, like paying bills and collecting a person's income. If the judge decides the conservatee cannot do it, conservatorship of the person in the estate goes for both general and limited conservatorship. You have to petition for both if you want to be conservator of the person and the estate. For most parents of intellectually and or disabled adults, conservatorship of the estate is not needed. We'll go a little bit further in the next slide. You do not need conservatorship of the estate if the developmental disabled adult you care for gets public assistance, like Supplemental Security Insurance, SSI, or Social Security, SSA, but has no other assets. Or the developmentally disabled adult earns a wage. But you need a conservatorship of the estate if the developmental disabled adult has other assets, such as inheritance or settlements from a lawsuit that is not in a special needs trust. Inheritance can be directed to a third-party special needs trust. A large settlement from a lawsuit will become assets of a disabled adult. Consult an attorney. This presentation and the website does not go into how to petition the court for conservatorship of the estate, mainly because most children with autism becoming adults don't have an estate. Representation of your adult child with disabilities during initial court determination of conservatorship. At 18-year-old, a person gains the rights and responsibilities, and the parents are no longer legally responsible. During the conservatorship process, an adult with disabilities will have to have a legal representation separate from the parents or proposed conservators. If the disabled adult has no estate or income, the representation will be appointed by the court. If the disabled adult has an estate of a sufficient amount, they will be charged for the legal representation until the estate amount goes under a certain amount. The amount varies by state. This is when the court appoints a lawyer that the service requirements to the court, that has service requirements to the court, which I was telling you about earlier. So there's a number of ways you get legal representation or self-help options, and we'll go over that uh, really quickly. You can get a pro bono lawyer. If your family income net worth is below a certain amount, you may qualify to have a lawyer to represent you pro bono. To find lawyers and to find out if you qualify, contact your local bar association and or visit probono.net. So you can also get family law assistance or facilitator in courthouses and legal assistant organizations. These are self-help services for family law matters and certain civil cases. They are available for self-represented court customers who seek legal information and resources. Their intention is to give everyone access to the courts. They can go by any acronym. They can go by many acronyms like ACCESS and are usually located in the courthouse itself. Similarly, there may be legal assistance non-profit organizations in your community. They often have information in many languages, and they can explain your legal options. They can give you the tools to represent yourself in court. They can show you how to fill out legal forms, review your filled out forms, and how to follow court procedures, and find resources or a lawyer. They cannot represent you in court. They cannot help you if you already have a lawyer. They cannot help you with certain types of court cases, but they can help you with conservatorship. Lawyers, you definitely need a lawyer if there's going to be any contesting of your conservatorship. If there's someone else who wants to be the conservator, or if two parents don't agree because they're divorced and it's contentious. Having a lawyer represent you does not necessarily make things easier, because you still have to give them all the information to fill out the forms and tell them so that they can tell them things so that they can represent you in court. Regardless, it is good to familiarize with the process of conservatorship before hiring a lawyer, as it will help you work with your lawyer. This website, raisingautism.net, will help with that. If you hire a lawyer, make sure the lawyer gives you copies of all forms filed with the clerk of court. Another option is the document preparer, and these are legal document assistants. In the United States, it is a non-lawyer authorized to assist with preparation of legal instruments. Unlike paralegals, legal document assistants do not work under the supervision of an attorney. They cannot represent you in court. They can fill out forms and file them with the court. They are less expensive than a lawyer. Basically, you're still giving them all the information to fill out the forms, and they just know which boxes to check. So there's doing it off this website will save you a lot of money. So this is the main page of raisingautism.net, and there are two ways to get to all the information you need to file for conservatorship of the person by yourself. And so each of the forms have their own web page, and we'll go into one that will give you an example of it. You can access it either by legal up here, and then down to conservatorship, and that'll open up California conservatorship of the person, and then timeline is what we'll go into a little bit later. And then you have all these forms that you go off of from this. There's also, you can enter it through down here, the conservatorship, and it has all the forms and links to all the forms that you need to. This conservatorship web page has like general information about conservatorship, like various definitions, it's an overview. So the next thing we're going to go to is California conservatorship of the person guide and timeline. And we'll go into that page. So this is the limited conservatorship of the person timeline and guide for California Conservator probate court. So at the beginning of each web page, you're going to find this has like the content, and for this it'll jump you down the web page, and if you want to go back up to content, there's top buttons throughout the thing. So it's all and the forms are also like this. The websites and forms are reproduced in text, so they can be translated to any language. Unfortunately, the PDF forms are in English, but a person in another language can use the website in their language and check or fill in the forms in English. Each web page has a content section at the top and top buttons throughout the web page, so you can jump around to inform you to the information you want easily. The contents on this web page are an outline of the whole process, from filing out forms to you being appointed a conservator. So this is just below the last slide that we were looking at that showed the contents, and this is the timeline for form filing, and it breaks down and links to the various forms that you need to file for conservatorship of the person, from the initial filing to when general plan for person and financial needs of the conservator, all the things that you need to file 60 days after you've been appointed conservator. We are going to focus on GC 310, petition for appointment of the probate conservator. This is the hardest form to file, and it's your petition to the court to be conservator. When we look at this one, it'll make all the other conservatorship forms easy to do if you can get through the first one. This one has a lot of attachments and a lot of things you have to fill in and information that you have to gather. It's the main form. It is recommended that you start conservatorship proceedings by filing at least 6 months before the proposed conservatee's 18th birthday. So it takes a while for the court to go through the conservator process. And notice that I said filing at six months. So you want to file with the court these initial filing forms. So you want to start the process of filling them out earlier. Once you get the hang of it, it's not that hard to fill out the forms. And it'll go by fairly quickly, and you'll see that when we look at the actual forms later in this presentation. So all the form instructions are filled out for parents filing for a typical conservatorship of their child with intellectual and developmental disabilities. There will be slight variations in how you fill out the form if you are a grandparent, sibling, guardian, or other person. These variations will be easy to change depending on your circumstances. Also, while we're on this page, we're not going to go into this as much. We'll talk a little bit about fee waiver, but we won't go into the forms. So there's these two forms Come on, laser pointer. There are these two forms right here, FW001 and FW003, that you have to fill out for waiving of court fees. The first one is the request to waive court fees. The W003GC is the court order that you'll get back waiving waiving your fee if it's granted by the court. This is often how this works. Is it's like a two-step process, and even the letter of conservatorship, which you will get back, is actually a form that you filled out, and they give it back to you. So with another attachment saying that the court has approved the conservatorship. California's court fee waiver is based on the assets and income of the proposed conservatee and not the parents. So for a disabled child turning 18-year-old that is not married, it would be a family of one, which with a monthly income of $1,237.50 or less. Also, there is an or between each possible qualification and not an and. So if you, the conservatee, are receiving public benefits like Medi-Cal, food stamps, CalFresh, CalWorks, General Assistance, SSI, SSP, Tribal TANF, IHHS, or CAPI, you also qualify for a court fee waiver. We already went into the household income of one person without a family, and then, or if the court finds that you do not have enough income to pay for the household basic needs and the court fees. All these will have your fee waived. There's more information on the forms themselves that you send into the court and the page notes. Or there's the link there that's also on the website to self-help fee waiver. This is the web page on raisingautism.net for GC310 petition for appointment of probate conservator. This is the main form that gets the ball rolling. You file it with your initial filing, and it's the most complicated form, and we're going to use this form as an example. Once you get an idea, it'll be easy to fill out all the other forms. At the top of the web page, you'll see that it says form links, and the links below are to forms that you can download. The first one is a filled-in example, the GC310 form. You can edit it. It's all these forms are already pre-filled out so that you can, for the typical situation of limited conservator of the person, for someone who is intellectually or developmentally disabled. And there's the next one is the attachments, and it's the same thing. We'll go into a little bit of this. You'll get a good idea of how this works. And then the contents. Each web page has an example of the web page, and then notes below it on exactly why the boxes are checked and what you should change and stuff. And then it also goes into the attachments. And then at the bottom we have it all done in HTML or text, so that it can be changed to any language. So by Google Translate. You can't file in another language, but at least they'll be able to look at the form on the website and look at the English form and fill out what they need to fill out correctly. All right. So this is the next, just below the contents, and this is an example of the first form. This would also be what it looks like when you download the form, except that the boxes are, it's a PDF, and the boxes are all, you can change the things. So we have at the top John and Jane Doe and their address, and you'll want to change all that. You won't have to change the attorney, petitioners in pro per. You want to keep that the same. This is the address for the San Francisco Superior Court of California. You'll have to find out where your Superior Court address is, and you can just Google that and find that out. This is the conservator of Terry Morgan Doe, so wherever you see Terry Morgan Doe, you got to change it to your the name of your proposed conservatee. The boxes are checked. We're going to go into down here. You can see it's C1, bond not required, and for reasons stated in attachment 1C, we'll go into that, and I'll come back to 1G because people often wonder why that box isn't checked. It says the proposed conservatee be adjusted to lack the capacity to give informed consent for medical treatment or healing by prayer, and that the proposed successor conservator of the person be granted the power specified in probate code section 2355. That box isn't checked. We'll go into that a little bit later. Notice that they'll have like successor, and that's just in case the conservatee has already been named, gone through the court process, and now we're going through a successor conservator. Then that box would be checked, and that's kind of all the way through. There's boxes for conservator or successor. Okay, so this is the page notes underneath the that form that we just saw, and you can see the start of the form, the page 2 of the GC 310 at the bottom of this slide. So the page notes give you tells you what is exactly what's in each box and why you need to check it, or why it is checked. So for 1C1, bond not required for reasons stated in 1C, it gives you an example of the attachment. But on the attachment, this example exists too. So we'll take a look at that, and then we'll come back and talk about 1G. So this is the attachment. In the attachment document, it's typical of a 1C to the petition. As a conservatee possesses no estate and only receives public benefits, petitioners respectfully request that bond be waived in this matter. Now, this is a Word document, so if the proposed conservatee does not receive public benefits, you can just delete that out and just say, as a conservatee possesses no estate. That works too. At the bottom of each of the attachments, you'll see this, and it says, in re of the matter of Terry Morgan Doe. You'll want to change that to your proposed conservatee's name. So we're back here at the page 1 of GC 310. I just want to point out real quickly that you'll get a case number when you first initially file, and you'll see this up near the top for court use only. That case number will be your case. You'll be given it when you're initially filed, and then you'll be able to fill in that case number on each successive form, and that's your number for basically the entirety of the conservatorship. So if you ever have to file or have the clerk of court look up one, you'll use that case number. The case numbers often look like it says PCN, which is probate case number, and then it starts with the year it was filed, so it's usually dash, like if it was 2016, it would be dash 16. And then it would be your case identifier number, which is usually about a 6-digit number. So you'll get that on your initial filing. Okay, so now we're going to talk about why you don't have to click on, why you don't have to check the 1G, because we're going to actually do that. That's in limited conservator. So the forms are made for both general conservatorship and limited conservatorship, and of the person and the estate. So there's lots of boxes being checked for different things depending on what you're doing. But since we're doing limited conservator of the person, we don't check this box because it's for general. So let's go. So if you notice here at the bottom again, the top of page 2, you'll see 1H, which is the next thing under 1G, and it says for limited conservator only, orders related to powers and duties of the proposed limited conservator of the person under probate court section 2351.5 be granted. And this is the attachments, and in the attachments this is where we request the medical, that we have control over the medical situation. Now you also notice that 1J says orders limited to civil rights of the proposed limited conservatorship be granted, limiting the civil rights. So the process is actually two-step, where you're in the attachments, on the form, the first 1H, you're asking for powers and duties to be granted to the conservator, and then 1J in the attachments, the court, you're asking the court to take away the rights from the limited conservatee. So it's kind of, everything's broken in court. Everything's broken down in increments, often, and so there's it's a two-step process, and we'll take a look at the attachments. Oh, okay. So before we go to the attachments, this is the notes for page 2. This would be right underneath that top section of page 2 that we saw. And one of the things that I want to say is that if the form says states a probate code section, I give you in the notes what the code is of that probate code section. So the A through B this is what the section of the welfare code, probate code that its actual reads like. And then further down here, I give you an example of the 1H attachment at the bottom of the slide, and this is the petitioner requests the following powers. This is also redone in the attachment, so you don't actually have to rewrite this all out. So this is the second page of the attachment that you can download, and this is a example and you can actually file this if all these are the powers that you want to get from the court as conservator. So this attachment is in the two-step process this is the part where the conservator, you're asking the court to take for the powers. So you read, the petitioner requests the following powers over the conservatee's person, and then it lists the following powers, and we'll look at the next slide and talk more about it. So this is 1J, and this is where the petitioner requests the court to limit the civil and legal rights of the proposed. And this is very, very much the same powers that you're asking, and it's pretty much the same words. And you'll notice that that you have the power. Number 5 is the power of the limited conservatee to give or withhold medical consent. So you're asking the court to give in the past, in the other attachment, you were asking for that, and now you're asking the court to limit that of the conservatee. So it's giving that. The limited. Okay, so one of the things that the regional center is going to do, if you're a regional center client, is, or even if you're not, they are going to, in their letter to the court, they're going to say that probably the conservatee should hold on to his social and sexual contacts and relationships, or the consent to marry. And that's number 3 and number 6 on this. Specifically, number 3, if even if the child is severely affected by intellectual disabilities. The reason for this is their mandate is the least restrictive possible. So in order to fulfill their mandate, they have to object to something. So the court realizes this. Every time this limited conservatorship of the person comes up for a intellectually disabled or developmentally disabled person, they get this letter from the regional centers, and there will always be some objection. So in some ways, when they do that, it's kind of rote. It loses its meaning or power, really. But the court generally sides with the parent. So if you write that in, then they'll side with you, and the investigator will probably side with you too. That's so you can change any of this. I mean, if you believe the conservatee on both of these attachments, you can change any of these powers that you want to take away, and you want to be granted to the conservator if you feel that it's different in your situation. These are all the powers that could possibly be taken away and granted to the conservator. So it's all changeable in a Word document thing. So this is the next page of the attachments, and I'm not really going into the forms parts because they're just the boxes checked, and there's notes on all this too, just like I showed you in the previous example. So in attachment 3F, to petition the proposed conservatee's relatives, there's a whole thing on the form where you identify all the relatives that are entitled to notice. And that's basically all of the relatives that are aunts and uncles, siblings, grandparents, and parents. And you'll list them, and you can even add an additional page if you have a large family that needs to be noticed. Attachment to petition allegations regarding proposed conservatee's preferences concerning the appointment of any conservator and proposed conservatee. So this is if your child has the ability to prefer, that you can write this down. If they're nonverbal or don't have the thing, then conservatee was diagnosed with autism, mental retardation at 3 years old or whatever age in your situation, and is not able to make such statement regarding his preference for the appointment of a conservator. If they are, then you can add that as that, and hopefully they're picking you as a parent. If they're not, then you probably need to talk to a lawyer. Alright, attachment 5C and 5C2, facts and support. And this also goes for the bottom thing, attachment 5F. Uh, so basically, facts and support. I wrote a whole thing called operating instructions for my son, and this was in middle school to give the teachers uh, an idea of what they're getting, because my son comes across as very easy and all that at first, and then he's like low incidence, but when he does have an incidences, they can be high, and he can be very crafty too. Um, so it's kind of like a warning, telling him what it's possible. So I included that. You can include the IEP. You can include anything. This is just uh, attachments that support your argument for conservator of the your child, and in that is also the proposed conservatee uh, is a 17-year-old autistic man slash woman. You can change that to just man or woman, depending on what your child is, and you can include that in your descriptions of the regarding the degree of developmental disabilities that your child has, including doctor things. Basically, any facts or documents that support your argument to the court and to the court investigator. Okay, so the next following slides weren't really part of the presentation at first. So this presentation was given at the Autism Society in November 16, 2019 conference, and this is from memory and not verbatim, but these are the questions that I was asked after giving the presentation. So the next bunch of slides are these questions, and I'm just going to read it in case you're not able to read them, or you're doing other things and you're just listening. So the question is, I am from an HMO. A psychiatrist must fill out a declaration of capacity, the GC 335 form, as part of the conservatorship process. The HMO insurance does not cover this. Answer: a school psychologist can fill out this form for free. They evaluate children at least triennially. The school has a stake in children to be conserved if it is needed. They do not want to have IEPs with a child who does not understand the IEP process and is not conserved. This presents lots of legal problems for them. To add to this, I'm going to say the parents can pay a psychiatrist to fill out the form. If the proposed conservatee gets SSI, that can be used to pay to have the form filled. It may be possible to have a regional center psychiatrist to fill out the form if the person is a regional center client, but again, that's they're kind of another party in this thing, so there's kind of a conflict of interest there. I would think it would be in the interest of HMOs and any health plans to have people conserved that need to be conserved. They should consider covering conservatorship capacity declarations, as it may cost insurance companies more in medical bills for an unconserved child that does not have the capacity to participate in medical decisions. My daughter was born with disabilities, and there is no real possibility of her learning enough to be capable of exercising her rights as an adult. Shouldn't I do general conservatorship of the person? Answer: you still need a limited conservatorship of the person because your child is born with the disabilities or diagnosed at a young age. The court holds out the possibility that a child born with disabilities has not yet reached their full potential. The legal system takes the removal of rights from an adult very seriously and want to take away only the rights that are necessary. General conservatorship is only for people not born with a disability but lose their capacity to exercise their rights. They had and exercised their rights throughout their life and are are in decline with little hope of being able to regain them. All powers of conservatorship you get in general conservatorship you can get in limited conservatorship. There is no added benefit of a general conservatorship. Question: if I need to pay bills for my child, then do I need to have conservatorship of the estate? Answer: you can still pay bills for your child under limited conservatorship of the person. You do not need conservatorship of the estate. Conservatorship of the estate is only for an individual that has assets that require monitoring by the court. This has been discussed previously in the slides. Question: I am confused about the talk of child and conservatorship. Answer: understandable. We are talking about children that are about to be considered adults legally. Since we are all parents, our children are always our children, even if they are adults. I use the word child in that way. Question: I am hearing talk of a children turning 18. My child is 21 years old. Is it too late to have him conserved? Answer: no, it is not too late. You can do limited conservatorship of the person at any time. If the conservator or conservators die or unable to continue to be conservators, then you would have to go through the process of conservatorship again. The age of the proposed conservatee does not matter as long as they are over 18. Question: if one conservator dies, but there are others still alive, do you have to go through the conservator process again? An attorney told me this. No, if one conservator dies, but there are other appointed conservators still alive, then the conservatorship is still in effect. You need to redo the conservatorship if all the conservators die, or you want to add a new conservator. Many parents put a younger adult child over the age of 18 as a conservator, so that when they pass away the conservatorship continues, and you don't have to go back to court to add your child. Question: if a conservatee signs a contract with a company or person and the conservator does not know or sign off, the conservatee is still responsible for that contract? Answer: no, the conservator must sign off on any contract. The contract cannot legally be enforced without the conservator's signature. Any company or person has no standing to enforce the contract, and they should have done their own due diligence. Question: what happens if you do not conserve your adult child? Answer: HIPAA does allow doctors and hospitals to share information if it is in the best interest of the patient. Some hospitals and doctors do not apply HIPAA correctly, so it is iffy. I have a whole section on HIPAA on the raisingautism.net website. You can read that, and HIPAA does allow doctors and hospitals to work with parents and share information if it's in the best interest of the patient. As stated during the general discussion, if your child is raped or molested, it has to be proved that they did not give consent. If they are not able to understand or state that they did not give consent, then the perpetrator cannot be charged. If the person is conserved and the conservator has the power to control sexual contact, then the perpetrator can be charged. It is a good reason to conserve your intellectually developmentally disabled adult child. To add this in regard to HIPAA, if you are an unmarried adult child who is normal and suffers an accident that causes a coma or otherwise becomes incapacitated, do doctors and hospitals not share medical information and decisions with those parents? Unlikely. They need to do what is in the best interest of the patient. So, if your child over 18 is not married, and he's in a motorcycle accident and becomes incapacitated, most hospitals and doctors will work with the parents of that child, adult child. So there's really no difference. It only gets different if child has is married. All right. Question: in attachment 5C1 and 5C2, facts in support, and attachment 5F, to petition allegations regarding nature and degree of conservatee's developmental disabilities, can you add things like his/her IEP? Yes, you can add his or her IEP, doctor records, and anything that supports your case that your child needs to be conserved, and why are you requesting powers as a conservator. You can also give your own written description and past events, including any time where he was 5150 or endangered to himself or others. These attachments to your petition to the court GC 310 form allow you to build your case for conservatorship.